You may be wondering why Attorney Noble is wearing sunglasses. It's because I'm paying homage to the Sunshine State. Florida passed a bill that went into effect July 1st, 2023. I'm going to chop it up. Stay tuned. Hey everybody, in case you're new here, I'm Jonathan Noble, divorce and family law attorney for over 20 years. And today we have a reason to celebrate, at least for the folks in Florida who are involved in a child custody case. In June of 2023, Ron DeSantis, the governor of Florida, signed into law House Bill 1301. I got a copy of it right here. And what it does, among other things, is in child custody cases in Florida, you walk in to court with a presumption that there should be equally shared custody between the parents. It's a rebuttable presumption, which means that the burden of proof is on the person claiming that the other parent certainly isn't fit or it's not in the child's best interest to have equally shared custody of the minor child. So the bill does other things, but I want to focus in on the fact that now, without any other evidence or anything else, the court defaults to 50-50 equally shared custody, if at all possible. Now, if the parents live 100 miles away, that's not going to happen most likely. But it used to be that there was no presumption. And I'm going to give you something to think about. The law in Pennsylvania, when it comes to that, is a presumption in cases concerning primary physical custody. And all Pennsylvania says is, in any action regarding custody of the child between the parents of the child, there shall be no presumption that custody should be awarded to a particular parent. So all that really does is it says, little kids don't necessarily need to be primarily with their mother. But what Florida did is they took a huge leap forward and they said, not only is there no presumption that primary custody should go to one parent or the other, but we're defaulting to equally shared custody. And you have the burden of proof, if you want anything other than that, by a preponderance of the evidence to show that equally shared custody is not in the best interest of the child. Now, there's something else I want you to think about. I don't know of any other jurisdiction that defaults to equally shared custody. They play around with it, they dance around with it, but they just came right out and said, all right, court, you got to follow the law. Default equally shared custody. That's a huge step forward. And it looks like it was 105 yeses and only 7 noes in the Florida House. And then Ron DeSantis signed it into law. Of the dozens and dozens and dozens of custody cases that I've been involved with and seen, it's unbelievable, but as soon as 2 people split up after they've had children, at least one of them makes these wild allegations that the other parent is somehow not fit. So I don't know why, but you married that person and you had children with that person, but as soon as you split up, they're a terrible parent. There are rare cases that I've seen where the other parent just can't find anything bad to say, but they're usually just still neutral. Once in a while, I'll see somebody say something really nice about the other parent, even though they don't like them. They are able to separate the fact that they are a good parent, but those are like 1 in 100. So hats off to Florida. If you're in a custody dispute there or you're filing to modify your custody order, they have to default to 50-50, but there's a rebuttable presumption that that's not in the best interest of the child. So I hope all 50 states follow this. There's a lot of lawyers that don't want to see this. Why? Because it will cut down on the amount of custody litigation, which is how they get paid. And sometimes custody litigation lasts for 18 years or longer, which is sad. Go default, everybody. And if you have enough evidence to show that it's not in the child's best interest, fine, then bring it to the court. But just because the other parent drinks when they don't have custody of the children, or you don't like the new person's significant other, that's not going to meet that rebuttable presumption, all right? The judges have already heard all that. It's got to be something significant. So hats off to Florida, other 49 states and all the commonwealths and jurisdictions in the U.S. and Canada, I'm talking to you. Go default 50-50, all right? Be careful out there. Drop a comment, like, subscribe. Love to have you as part of the community.